Next on our agenda, we have a panel discussion on mergers and acquisitions. I hope that this panel discussion turns out to be very beneficial for the law students, especially because I feel mergers and acquisition is kind of the hot selling legal sector, because I see most of the courses being offered in this sector, and even if you open any top tier law firm's website, most of the positions are being offered in this sector. And I hope that this discussion helps you understand the nuances of the job and what exactly do these people deal in better. This upcoming panel discussion is about mergers and acquisition, and as I was saying, I think it will be a very good discussion for the law students necessarily, because mergers and acquisitions is often considered to be the hot selling legal sector, because most of the jobs and courses which are being offered to law students are typically related to mergers and acquisitions. So I hope that all the law students get to learn and actually get to know the intricacies of day-to-day workings and what does a job in the mergers and acquisition field necessarily involve through our panelists. I'll just quickly introduce all our panelists. First, we have Mr. Joy Jain. Mr. Joy Jain is a chartered accountant. He worked with the PwC for 27 years and over 15 years as a partner, focusing mainly on due diligence reviews, valuations, and corporate restructuring. He worked with a number of law firms on such project. He has been on his own for last 11.5 years, focusing primarily on valuations, accounting advisory, and corporate restructuring work. Next we have Manvinder Singh. Manvinder Singh, sir, is a partner at Jyoti Sagar and Associates. He specializes in M&A and transactions, and he also has an experience of more than 2 decades. He started his career in-house with a listed oil and gas company as their company secretary. In terms of transactions, he has done large M&A transactions, a number of VC transactions in new age sectors like crypto, NFTs, edtech, fintech, e-commerce, etc. Next we have Minal Madan. Minal Madan, a GLC Mumbai alumni, began her career as a corporate lawyer doing M&A and PE transactions. Subsequently, she was exposed to early stage investing and got a chance to start representing a few of the world's most active venture capitalist investors in Delhi, NCR and Mumbai, while working with law firms such as AZB and SAM. Next we have Yogeesh Chandra, sir. Yogeesh Chandra is the Chief Strategy Officer at RateGain, India's first SaaS company to be listed on the Indian capital markets. Over the past 14 years at RateGain, he has worn multiple hats, including heading product, marketing, commercial and corporate developments. He also has carried out multiple acquisitions across Europe and US. Also, he did a fundraising event as well as a successful listing in 2021. Lastly, we have Varun Vaish, sir. Varun, sir, comes with over a decade experience in M&A, private equity and general corporate advisory. Varun sir's involvement in various transactions helped both the investor as well as the target company navigate a very uncertain regulatory environment and close large investment rounds. He has played instrumental role in bringing clarity on certain grey areas of the regulatory framework, for instance, surrounding restructuring of such ECB loans. That was the round of introductions. Most of the panelists, I would say, here are more experienced than what my combined age is, so I think we'll all get to learn a lot.
Yeah, good afternoon. My name is Joy Jain, and I will just start the session, and after me I will request all my co-panelists to speak for a while, and then we will go on to question and answers. So just to introduce the M&A process, and especially for those who have not been involved in M&A, we have something called deal making, which is where the M&A transaction actually happens. So it starts with identifying a buyer, identifying a seller, or a target as we call it, then going to exchange some information. Normally it's called confidential information memorandum. Then there is an indicative bid by the buyer. Then there is a term sheet or an MOU, which basically gives a non-binding terms and conditions. Then there is a due diligence. Due diligences can be of various types: legal due diligence, financial, taxation, operational, market. There are various types of due diligences. And then the parties negotiate, agree on how the transaction should be structured, and enter into transaction documents. So I'll just come to the transaction documents. And then there could be certain conditions precedent, which are certain conditions to be met before the transaction happens. That could be regulatory approvals, or that could be certain other conditions to be met. And once those conditions are met, the transaction is closed. So coming to the transaction documents, there could be, depending on the structure of the transaction, what the transaction is, there could be a share subscription agreement where the acquirer is taking on new shares, or there could be a share transfer agreement, which is called a share purchase agreement, a business transfer agreement. There could be a scheme of mergers or demergers, and there could be a slump sale, or even some cases there could be a scheme of capital reduction, so which I have seen. And normally when we talk about laws, one is what are the laws that affect the transaction, and secondly, how do they interact with the business. So coming to laws, first of all, the basic law that we start with is the Contract Act, because that is where the validity of contracts gets established. Then we have the Companies Act, which covers issue of new shares, transfer of shares, corporate restructuring, which is mergers, demergers, capital reduction, buyback. So various things, even an investment to be made by the company. So when an acquirer is buying a shares, they have to take certain approvals as are required under the Companies Act. Then for listed companies, there are SEBI regulations which come into the picture. There are takeover regulations, there are ICDR regulations, there are requirements with regards to mergers and demergers. So then there are FDI policy, FEMA Act along with FEMA rules for FDI and ODI. ODI is overseas direct investment, FDI is foreign direct investment into India. Then there are taxation laws like income tax law, which governs how the transactions will be taxed, whether there will be capital gains, there will be dividend, whatever the different types of taxation will be there. Then there is stamp duty. So on transfer of property or business, stamp duties have to be paid, and different rates, states have different rates of stamp duty. And there could be double taxation also, because if there are properties in different states, or if parties are registered in different states, then both the states might ask for stamp duty. Then in some cases, GST also comes into the picture. And also there could be cases where the input tax credit that particularly the target has, that may be denied in certain cases. So these are various laws. And then there is, of course, the Competition Act. So transactions beyond a certain size, or transactions where the acquirer or the target are of a certain size, whether in turnover or in net worth, net assets, they have to go and take the approval of the Competition Commission of India. And the Competition Commission of India may either approve the transaction, reject the transaction, or impose certain conditions. Of course, they discuss with the parties to arrive at what those conditions will be. A recent example is of Air India and Vistara merger that you would have heard. So there certain commitments were made. So Air India, Vistara, for example, they agreed that they will not reduce flights on certain routes. Instead, they will add the flights. And they will give away certain slots that they had, which were unused slots. So these kind of commitments, Competition Commission might ask. And then now we also have Insolvency and Bankruptcy Act. So for distressed companies, a lot of acquirers are acquiring companies or businesses through the CIRP process. So we have all these various laws, and then we also have sector-specific laws for telecom, for banking, NBFCs, insurance, airports and others, where the sector regulator also has to approve the transactions. So a lot of laws that we have to contend with. And then there is an issue of taxation I've already mentioned. And then when we come to international transactions, so there could be issues of, well, there could be laws of the overseas jurisdiction that also come into play. For example, when Tata Motors bought Jaguar Land Rover, they had to take approval of the European Commission. So these kind of things also happen. And of course, when we talk about tax, then double taxation avoidance treaties will come into play. GAR will also come into play. Things like that come into the picture. So, and then when we talk about a business, again, if it is a regulated business, then what regulations apply on that business also affect the transaction. For example, if we talk about banking, and you would have all heard that the banks have to maintain certain ratios, cash reserve ratio, statutory liquidity ratio, and things like that. And when there was this recent merger of HDFC Limited into HDFC Bank, and HDFC Bank wanted certain relaxations from these ratios, the RBI did not give those relaxations. So it depends upon the regulator, and so they have to then go and structure the transaction accordingly. So these are the various cases, and so now I would like to hand over to Mr. Yogeesh to sort of give his views.
Thank you. Thank you. First of all, thank you, Oakbridge, and thank you. It's a pleasure to be here. It's the first edition, and I look forward to a greater turnout next year. But an absolute privilege to be here. So the perspective that I was going to bring in today's session is, I'm a business, and when I engage any law firm to do an M&A transaction, what is the expectation that I have? And you know, the legal firm that is engaged with the spirit of true partnership. So first of all, you look at the expertise and the experience in that space. You know, Joy, in his opening comments, spoke extensively, but a lot of nuances are industry specific. So it's always good to see what is, you know, what's the experience been in your sector. Secondly, you should look at some strategic counseling. So, you know, besides what is there in terms of the job assigned, in terms of the doing the DD or making definitive documents or discussing reps and warranties, what is the strategic counseling that the law firm can offer to you? Thirdly, I've noticed, especially in a lot of cases, law firms try to take on a lot of work, and then the DD process kind of has the risk of getting delayed. So it's always good to be transparent and say, this is the amount of bandwidth I can provide. And finally, some transparent pricing structure. Again, in cross-border, how time is treated and how money is treated is very different and can have cultural nuances. So it's always good to keep in mind, because from a business perspective, a business is trying to be opportunistic in a certain window to make an acquisition happen. And one of the biggest tools they have in terms of negotiating or getting the deal is that they would close faster than others. So the agility and the support that one gets from a law firm is immense. And besides that, besides these very fundamental points, the objective of the law firm is that 5 years, 10 years, 20 years, anything that was negotiated should not come back in a way that you would think the contract could be more watertight. So it's very, very important that that perspective is kept in mind. Things like non-compete, things like IP infringement. These are very, very critical, and I have seen these come back at some point of time. So if you are not protected at the right time, you know, a lot of value that you are willing to create out of any transaction can get diluted. So that was my perspective, and hopefully we'll talk on other things as well. I'll just pass it on to Manvinder.
Thanks, Yogesh. I think I'm a partner with JSA. At JSA, M&A and private equity transactions are frankly our bread and butter. We do significantly large transactions, be it cross-border, domestic, so we keep doing that. I think Joy already mentioned about, you know, what kind of M&A transactions are there. I would not repeat that, but I just wanted to say, so what Joy mentioned, that there could be business transfer agreements, stock purchase agreements, there could be mergers, there could be, you know, some other collaborations as well, like Sometimes we have these profit sharing arrangements where you're not really a partner in the sort of invested in the company, but you're reaping the benefits of the business in some sort of a profit arrangement. Uh, those kind of arrangements could be there, or it's their pipe deals. So, but how do you choose which kind of transaction do you really want to undertake? Whether it will be a merger simpliciter, or you want to acquire a business but not really acquire the the company in that sense, because there could be historic liabilities with the company. So one typically likes to take the decision based on various factors, and law comes into picture while analyzing all of those factors, which basically are how much cost do you really want to spend, what's the transaction cost in that sense. So depending on which is the more tax efficient or a cost efficient method, you will pick one of the different modes of undertaking a transaction. Um, there could be, like I said, tax not only on the seller, but there could be tax on the buyer. Not tax on the buyer, but there could be tax benefits that might accrue to the buyer. There could be depreciation claims that one could claim. So depending on which is really a cost efficient, tax efficient, and sometimes even time efficient. So in a large number of M&A transactions that we've seen, you're sometimes pitched against other suitors, especially during the COVID time. There were a lot of investments for a very small number of companies, and you would see a lot of, there was frankly a valuation bubble in that time. But really, all of these private equity investors were really competing with each other to invest into certain companies. So sometimes the timing becomes very crucial factor. Or sometimes like right now it's a funding winter. Companies might just be dying, so you can't really wait for a mode of acquisition which is very time consuming. The company might just go down under during that time. Sometimes timing becomes a huge issue. There may be regulatory approvals. So one undertakes an M&A transaction keeping all of these factors in mind, being cost, tax, timing, and you have to also look at which is the best mode for you from a risks and liabilities perspective. Like in a typical business transfer, you might be able to pick and choose which liabilities you want to take over and which you want to leave behind, which may not be possible in a typical stock purchase or a merger transaction where you're practically succeeding into the company, and you're practically you'll be liable for everything, all the historic liabilities, etc. So I think depending on and then there are ways to mitigate those risks, etc. as well. But so depending on all of these things, you tend to structure the transaction. And once the structure is there, then you undertake diligence. There will be documentation. But lately, increasingly, that we've seen that the transactions have become very, very complex these days. You might, you may have agreed to a certain price, or sometimes you are not even able to agree to actually a price. So there will be valuation gaps between what the seller wants, what the buyer is agreeable to pay. So you have all of these structures where you are able to undertake the transaction even before sort of concluding on the price. So we call it earn-out structures, where practically you end up paying some part of the price depending on future performance of the business, which could be maybe linked to future EBITDA, the next financial year's earnings of the company. So sometimes you structure your transactions in such a complex manner that you've actually undertaken the transaction, but consideration is still not sort of final. I mean, it will be, the principles would be final, but not the exact precise amount would be final. So what we're really seeing is that transactions have become really sophisticated in some sense, and there will be, there are all of these structures in place, be it earn-out. You would have deferred consideration structures where some part would be paid later. You would have holdbacks into escrows, so that in case there are new liabilities were to come up, then at least there's a holdback, and the consideration will get paid a little later. I think Joy also mentioned about CPs and CSs and condition precedent and condition subsequent. so sometimes there are some significant issues that needs to be addressed. So, and who's going to bear expenses for all of that? So I think so some of those aspects are also, taken into care while undertaking a transaction. And if you're doing a transaction for a listed company, I think it's a totally different ball game. The securities laws come into picture. The disclosure requirements are extremely, stringent. There are issues with what time even the board needs to get involved, because it will trigger disclosure requirements to the public, and you may like to involve the public at a stage where the transaction is near to the final, not it's in a very early stage. So those kind of issues, and then takeover code. If you are acquiring a certain percentage in the company, then you have to give an exit to the smaller shareholders, so they also get sort of impacted by M&A transactions for a listed company. There are all of those insider trading regulations one need to take care of. Even for your own employees, there are stringent provisions with respect to how they need to access the information, how can they really deal in this stock shares during the time there's unpublished price sensitive information, etc. So frankly, I can go on and on, but I think I touched upon some basic concepts with respect to how the transaction, how you pick the structure, and how how typically you find complexities in a transaction. Minal?
Thank you.
Testing. Yeah, sound.
Hi everyone, my name is Minal. Thank you for my co-panelist. I would like to try to cover topics which have not been discussed earlier, and my experience in the M&A sector that has been, especially in the recent industry, with the startup industry, how it's coming about. So I would like to, explain from my perspective the M&A sector as one of the most, we all know it's one of the most upcoming sectors in India. So I think that's one good thing, that there's enough education and understanding out there. But if I have to put it from a Shark Tank's perspective, because I think that's much more easy to understand and to relate to, what happens is what we see in newspapers and Shark Tanks, those are PE-VC deals. They are not M&A activities. I think that is one distinction I would like to clarify. M&A activity happens when the company is in a position that it can acquire a competitor in the industry, or it can acquire a business that is complementary to its business. So that is one distinction that is very important. At a startup stage, companies do not have the wherewithal to, buy another company or buy an asset of a company. They are looking for investment in itself. So that is the difference between a PE funding, VC funding versus an M&A activity. And we also have to understand, with the level of PE and VC funding that we have seen in the recent past, the next natural progression is by default your M&A activity. Because the companies are growing, the bases are growing, they have funds, they want to grow faster, they want to cross sectors. So there are many examples of that, 1MG, Tata coming into omni-channels, coming into picture. So I think this is a very good example of how the market is going, where the market is going. And in the larger sense of the business, I think we have to understand that mergers and acquisition is an activity where businesses can find ways to make the most out of their current business, or how to increase their business to acquire a bigger part of the profit sector in a different industry. Obviously, there are industry-specific sectors. So I think the biggest problem in the M&A sector is that at least I have seen is, if a manufacturing entity has a license which cannot be transferred, how do you structure that transaction? Because in such transactions, what happens is your basic principles of structuring cannot apply. As lawyers, all M&A lawyers will do structuring. Tax lawyers will also advise on structuring. But in essence, if I cannot change the basis, be it a license, be it a government authority application that has been approved, if there are these licenses that cannot be transferred, standard principles cannot apply. So that is where we have to be creative, as my co-panelists also mentioned. That is where your technical understanding comes into picture, the specialization, the customization of transactions. That is where it comes into picture. So I think M&A in itself does have a lot of legal angles where we do a value add as a law firm. And where we do a value add is to guide our clients. We have to understand our clients' core activity is business. When they hire us as their lawyers, they want us to be masters at our core activity. And our core activity is legal industry, understanding how the laws work around it, understanding what is the applicability of the laws, understanding how is that law going to affect my client basis the interpretation that I'm giving it. So it is not a matter of how you're interpreting the law. It is also a matter of how the department is going to interpret the law. Because basis our interpretation, the department is not going to get convinced if the department has a different stand on that particular piece of law. So I think in M&A we have to first understand, obviously this is done post the due diligence process as to what are the red flags. What we have to understand is that in most transactions, legal comes across as a cost. If we have any cost related factors in relation to legal, that can be covered by the parties that are entering into the transaction, because valuation is not our concern. Valuation is a different concern. But our job is to give the information. But on the other hand, if there are legal blockages, if there are problems, that will put an issue in the entire transaction. For example, I mentioned the single issue that licenses cannot be transferred, registration cannot be transferred. In such an issue, we have to find a structure, because without the registration, the business, the value of the company cannot be derived. And if you, go home and do a little bit of homework on this topic as well, you will find there are multiple strategies in M&A. I would like to take an example of a hostile takeover, right? Like in a hostile takeover, what are the strategies that are used to prevent a hostile takeover from happening? So you will see that those strategies are actually derived from the same strategies that are used to ensure that a transaction actually sees fruition. So it is a very thin line to understand what are the absolute red flags that are a no-go, which between the parties cannot be solved, and one has to go to the government authority to get the approval, because that is a third-party approval. That is where the real problems are going to come in. But if there are matters that can be handled inside the team, that is given a little bit of, let's say, less importance, because these are matters that can be solved inside the team. Also, I would like to point out one more very important thing. We have to always understand M&A is a group activity. M&A cannot be done in isolation. There are minimum 6-7 parties involved. One will be your buyer, one will be your seller, one will be your legal advisor, then will be your financial advisor, then will be your tax advisor, can be an environmental advisor, any other technical advisor. So always remember, M&A is a group activity. Any activities of you going to a different company's office, you are going on behalf of your client. But if you're going to another company's office asking for documents, what is the guarantee that they'll give you all the documents? Because the entire basis of a DD report, the laws that we apply on a DD report, they are done on the facts that the company provides us. So if the very fact in itself is not correct, if we have not done our document extraction properly, the very bases are not correct, then obviously our interpretation of law will not apply. Going forward, the advice we have given would need to be, changed. So these are aspects where we have to understand that there are human aspects involved. It cannot be in only in numbers. There's a very common reference, an M&A activity is compared to a marriage of business also in many cases, because it is true. If you go by an arranged marriage case, it is very true in what happens in an M&A activity. You have to understand, merger still is a court-induced process. An acquisition is not. It is a contractual agreement, and the only recourse is to go to the court of law to file an indemnity claim. So if I am a buyer, I'm investing hundreds of crores to buy a technology, or to buy an asset, or to buy a company. What is it that I am looking? It is not just, there are employee issues, post a merger or an acquisition. Employee integration is a big issue. So it is not just the numbers factor that we have to be careful about, but we have to also understand that there's a human factor involved in this. Thank you.
Right. Thank you, everyone, for being here. Thank you, Joy sir, for sort of setting up everything, and to Yogesh and Manvinder sir for sharing their experiences, including you, Minal. So I'd just like to take a minute to talk about M&A is really a fantastic barometer for how the economy is doing, right? Why do we have something like M&A in place to begin with. The idea is for capital to really flow from non-deserving businesses to businesses that can put it to the best use, right? And it's these M&A structures that enable businesses to grow inorganically and grow fast so that they can sort of put capital to use in the most efficient manner, right? If one were to see how long it took an established company like the Tata Group to reach $1 billion in market capitalization, they took almost 100 years. But Zomato did it in less than 4 years, right? And a lot of this wealth creation and growth happens because there is something like M&A, right? Of course, the law, when there is an activity that's being undertaken and there's a vast amount of money that's involved and there is capital of the common man that's involved in a lot of these businesses, the government would like to get involved, right? And there would be certain measures that the government would take to ensure that this activity is done in a fair manner and in a regulated manner, right? And that's where, when Mr. Joy spoke about all the various laws that apply, it's basically the government trying to ensure that this takes place in a coherent and efficient manner, right? And navigating this regulatory environment is the job of a lawyer, really, right? It's very simple. At the core of it, it's just a sale transaction. Somebody wants to buy something, somebody wants to sell it, a price is decided, and you go ahead with it. But there are a myriad of other factors that come into play, right? If money to buy a particular asset or a company is coming in from abroad, the government gets involved. They're like, okay, we don't want certain strategic interests of the country to be harmed. We don't want Indian businesses to be sold to foreigners, right? And in India, you must understand that there is quite a lot of baggage we have with respect to foreign businesses owning our resources, right? All of you are aware that at one point of time, the East Indian Company came to the country to do trade, and they landed up exerting a lot of political power, right? So from that baggage, we have an entire regime of regulating foreign capital coming into the country, which has a major impact on buying and selling transactions, right? You obviously also have your the Companies Act, which governs these sale transactions. It wants to ensure that existing shareholders are aware if they are being diluted, that certain existing shareholders have preemptive rights. So there are mechanisms in place for how new capital is issued in a company, and that is often the way in which a company is acquired, right? You also have sector-specific regulations, right? In the insurance sector, you have IRDA, you have various other regulators who are ensuring such acquisition activity in their sectors, ensuring that things are above board. So lawyers, through documentation, through ensuring sort of parties reach a consensus at item quickly, and as Manvinder sir said, structure it in a manner that is efficient and is cost effective and also takes place within a quick period of time. That is really our role within this environment that we work in. Documentation, of course, plays a huge role. But more importantly, one must understand that the laws in this country are rapidly changing, right? And a lot of those new legislations have an impact on every business, whether it's data privacy, or whether it's the revised competition thresholds. So a good lawyer is aware of how these changing legislations are impacting a particular transaction and ensures that it's structured in a way that it's completely legally compliant yet takes place quickly, right? So the better lawyers do their work, the more M&A activity happens in terms of volumes and in terms of deal number, the faster capital moves into right hands and businesses are run by people who can run them efficiently, right? That is essentially what all of these stakeholders on this panel also do. We sort of ensure that we're a small cog in India's economy, ensuring that this activity takes place above board and money moves in the right hand. That is in crux M&A. That is the intersection between the law and the business side of it, right? And that's my 2 cents on this topic. Back to you, Joy sir.
Yeah, sure.
So, one of the things that Varun mentioned is the whole value creation and the responsibility of doing the documentation right. I wanted to give an example of how through this we have once benefited thanks to the legal firm that we had deployed. So this was a transaction that we were carrying out with a company in the US. It was it was the diligence of the law firm that went through the contracts, the vendor contracts of the target company in so much detail and finding out who their stakeholders are to realize that one of the employees was was running a company as a vendor. And the fee being charged, I would say, was about 18x of the fee that was the market rate prevailing. So that was a clear value creation for us because the moment we realized it, and it was an asset purchase, so we could choose which contracts to take, which contracts not to. We just shifted that task back to India. It was monitoring something that would basically never break, and for that millions of dollars were being charged. And it was this spotting by the legal firm that helped us not only create better value out of the transaction, but also negotiate better. Another example, a more generic one, is the holdbacks that Manvinder was talking about. Is when you read through the contract and you understand that there could be liabilities that could come back later, gives you a very good negotiation tool. So your lawyers, your legal firm can equip you, while they don't directly do the valuation, but valuation is not just a number. Valuation is the whole deal in the way it is packaged. And to a very large extent, the legal firm becomes your coach in guiding you through creating much better value by negotiating terms around valuations, like what can be held back, what can be paid back later. And the contracting itself, again to Varun's point, needs to be so specific because when the marriage is about to happen, then everybody is very excited. And people talk about, oh, we'll come together, the energies of 1 plus 1 will become 11 or sometimes 111. But then you realize that, okay, for this growth to happen, for me to meet my earnouts, I would expect some support from the holding company, and the holding company is like, we have not documented that. So that's where the friction starts. And a good documentation, clearly draws the line so that in case there is a dispute, you're protected. So these are some examples through which a legal firm can create immense value for the company that it has engaged. Back to you, Joy.
Thank you. So we are running out of time, but we can take a couple of questions if anybody has. Yeah.
Deliberations, I noted certain questions I had. So the first question was a subject-specific question. I am a student of law, third year. I've been reading Section 135 CSR activities under Companies Act. I wanted to know, as Sir mentioned, that there are certain settlements with companies do during mergers. They do during mergers to settle out that who will do what in case of a merger happens. So, Sir, in that case, how is CSR handled? How is the CSR responsibility, which both the companies need to undertake to a certain criteria? How do they manage it? That's my question to you, sir, since you mentioned the first speaker, you, sir. And, sir, and my second question is for you. Since you mentioned the misinformation point, are there any measures which audit that the information given to merger officers, like you become one, are there any such measures, and how can lawyers on a personal scale avoid such measures?
Let him start.
So would you like to answer first?
Please, sir, you start.
So basically, to CSR, basically now it's a question of a liability. Companies have to mandatorily spend 2% of their profits, average profits of the last 3 years. That's a requirement under law. So on the date of the transaction, if there is an unspent amount, that will be treated as a liability and carried forward after the transaction, basically. So it's not necessary that the company, that the buyer, that the seller or the target has to necessarily spend it before the transaction happens. That's not necessary. That can be carried forward as a liability and spent later on.
So in relation to misinformation, I hope I'm audible. So there are various ways to tackle this problem. First is, what is the method of due diligence? If the method of due diligence is a physical due diligence, then the entire online process does not come into the picture, right? So physical due diligence, generally what happens is, as law firms, we make a copy of a list of all the documents. Every single document that we have received from the company, we prepare a list of that document, we get it verified from the company, we mention it by the name of the document, the date, what is the information it provides. Because let's say if they are just sales invoices, GST invoices, every month there's a filing. So I will have a huge bucket of file. So instead of writing it, let's say month by month, then to reduce my work, I can say, okay, 2013 to 2014, GST, X location or all India location. So if you're doing a physical due diligence, which happens very less these days, the issue is that the information is not shared over a medium which is captured. So to capture that information, we write that information in a tabular manner and we share that with the company saying, kindly certify that these are the documents that you've shared with us and this is the information that we have relied on. Another aspect of this, if we go to the online due diligence process, firstly, there are data rooms. There are various levels of data rooms. I'm not talking about a simple Google Drive or a OneDrive. That is, you can definitely create a data room there. But if you go to dedicated data rooms, if it is a very high level, high value M&A deal, the data rooms have a lot of limitations and restrictions. And it also has doc records, like an audit trail. How you have seen when you sign documents online, now there's a concept of audit trail. The same way there is a concept of audit trail even in online due diligence. The document which is uploaded, it will provide all the dates. Who has uploaded it? When was it uploaded? When was it opened? Is it printable, not printable? If it is printable, who took a print? Which date? When? So that anyone who has had access to that document can be tracked and later, if required, can be called upon to present those documents that were taken. If we now go to the recording aspect, now we've dealt with how we get the information. One is online, one is offline. Now if we go into the aspect of how do we record that information. In your due diligence list, we obviously make that list of documents that we capture. There are also documents that we can add in your multiple steps of the document. For example, there are CPs, there are CS. You can add some of the things there if you need extra documentation or you need an action to be taken on a documentation. The same way, if a documentation has not been provided or if it is very important, a soft copy has been provided, a hard copy has not been, has not received. In such cases, you can put them in the indemnities and warranties clause. So you have to understand how you're dealing with the issue. Sure. You have to understand how you can deal with the issue. Always there is possibility in documentation. If there is no possibility, no one stops you from creating that possibility. That is also an art. Law is just not the practice of law. It can also be an art by how you interpret it. So it is obviously, it's left to the imagination. As long as it's legal, you can find various routes to how to pick that clause, how to tackle that problem, so that the resolution you're looking for can be achieved.
Let me expand on the reps warranties you mentioned.
Thank you.
So you don't do the deal simply, of course, diligence is extremely important, but you don't do the deal simply relying totally on the diligence. You always seek certain representations, warranties from the seller in your contract. And typically those reps warranties are always qualified by what we call a disclosure schedule, wherein the seller tells you exactly what exceptions are to certain reps. I would say these 100 rupees are your liabilities and there are no more, or your only tax demand is 100 rupees and no more. But then the seller will come and say, no, well, there is this litigation going on. There could be a potential liability. There is this tax assessment which is not completed, and therefore there could be a potential tax liability. So at some point in time, your risk allocation is not just depend on your own diligence, which is obviously extremely important, but actually the risk allocation is there typically in the contract through reps warranties and corresponding disclosure, where you with your open eyes you assess, well, this is the risk going forward, and who's going to take what part of that risk. So So it's typically all well documented in an M&A transaction.
So I think we have run out of time now, so I'll hand it over back to you. And thank you everyone for patient listening.
Yeah, first of all, I would request you all to give a huge round of applause to all our panelists. They have showcased remarkable command on the law and their extraordinary ability to distill complex concepts into digestible insights. So I think it was a good learning experience for you. Now I request Dhyani sir to present all the panelists with mementos. I request you to first present it to Joy sir. Manvinder sir. Mrinal ma'am. Wes sir. I'm really sorry, Yogeesh sir. We couldn't get your memento prepared timely. There were some technical issues. Yeah, we'll send it to you over after the event. I would request all the panelists to click a group picture with Dhyani sir. Give them a huge round of applause.